On this episode of Law Weekly, we talk about the ongoing process of constitution amendment against the background of the just concluded nationwide consultation by the National Assembly on the process. We speak to Senior Advocate of Nigeria, Bode Olanipekun, on the prevailing issues, one of which is whether an amendment will suffice, despite the clamor in some quarters for a brand new constitution. Bode Olanipekun is one of the few senior advocates of Nigeria under the age of 40. And at his elevation in 2018, he was the youngest senior advocate of Nigeria. Bode holds a master's degree in international commercial and maritime law from the University of Wales and is a member of Maritime Arbitrators Association of Nigeria, Chartered Institute of Arbitrators United Kingdom and Nigeria. He has vast experience and has been consistently involved in high-profile litigations on constitutional, electoral, energy, and other matters. He's also been in various specialized non-litigation transactional legal practice and continues to act as counsel and arbitrator for numerous indigenous and foreign firms doing business in Nigeria and across Africa in diverse areas of law. Last week on the show, I showed you some of his submissions before the Southwest Constitution Review public hearing in Lagos. Does he think that the exercise was robust enough? That's the starting point of this conversation. Enjoy.
It's arguable whether it is a step in the right direction or not. Now, will the step that has been taken, will the outcome of the steps being taken reflect the aspirations of Nigerians? Well, I can't tell for now, but the truth of the matter is at every stage in national development, leadership must consult. I see it as some form of consultation. Representations were made to parliamentarians. We can only hope that those representations will be reflected in the outcome of the process. But yes, they got sufficient reactions from Nigerians as to how we want as to what we want in our governing document, which is the Constitution. Yeah, they got sufficient information. I think so.
Okay, so let's talk about the process of constitutional amendment itself. Some commentators have argued that merely amending the Constitution will not solve the challenges, that what we need is a brand new Constitution. Others say a brand new Constitution that makes provision for physical restructuring and devolution of powers. Others believe that an amendment will solve the problem. What do you think?
So, let me start from the position that can hardly be contested, that the preamble to the 1999 Constitution is not 100% true, where the Constitution represents that we, the people of the Federal Republic of Nigeria, have given ourselves this Constitution. Having said that, is the Constitution of Nigeria, the 1999 Constitution of Nigeria today, an operative law? Yes. Does it command compliance? Yes, it does. Against that background, we can then progress to what the provisions are as to whether the process of amendment is legal. Section 9 is clear in the Constitution. It permits an amendment. Now, legally speaking, there are judicial authorities that say that an amendment includes substitution and replacement. Of course, there's also the other side of the argument that can you place something on nothing? Well, again, that's a generalized view that people sort of take to the extreme, because at times you can, something can come out of a process that is not 100% solid. You can still build on it. So, if this amendment process reflects the aspirations of Nigerians, I think it will solve the problems that come up, devolution of power and all of those. Will this amendment process solve the problem? I don't know. Can this amendment process solve the problem? Yes, it can. The proponents for a brand new constitution also have very valid basis of asking for a brand new constitution, and one of the bases is the fact that we, the people of Nigeria, did not give ourselves this constitution. So let's work from a solution or end result point of view, right? If we can achieve what we need is a constitution that addresses how we as Nigerians are governed, that addresses how the various nationalities that comprise Nigeria, how we coexist together. So if we identify what we want and an amendment can give us what we want,
why not?
Why not? If it's a new constitution that will give us what we want, why not? But what we should not lose sight of is what exactly do we want
to achieve.
Mm-hmm. And I think honestly that if the National Assembly is willing to go the whole log, an amendment can achieve it if it addresses the many aspirations of Nigerians.
Yeah, I want to take a cue from one of the things that you said about governance, we the people. Now, we're aware of IPOB and groups that want to go their separate ways. So how confident, or what do you think, how can we address the issues of people like that who don't even believe in the Nigeria, who want to secede and stay on their own, IPOB and all of those groups, in the making of a constitution? As you've said, this process can give us a new constitution if that is what we desire, because there is a provision for it in the constitution already.
So, thank you. You see, let's appreciate that some things led to these agitations by these various groups. So, they have grievances. Now, are they going about their grievances the right way?
Debatable.
It's debatable, right? So what a constitution making or a constitution review process will do is would allow a sit down with all these groups, right? What are your grievances? How will those grievances be addressed, right? And look, let's face it, what exactly do these separatist groups want? They want greater control of power at the local levels. So they want governance closer to the people. I honestly think that asking for devolution of powers is a legitimate demand, right? If the center sheds off, quite a number of load in terms of, again, items, for instance, on the exclusive legislative list. I think if quite a number of those powers are devolved to the constituent units, these agitations would actually reduce if they don't vanish altogether. I think so.
And the time has come for the center to shed some of this weight.
Oh, no doubt about it. No doubt about it. I don't think I've heard any convincing argument why the center should not shed those powers. In any event, what we're seeing in Nigeria today is proof that we cannot continue to be governed, or we cannot continue to coexist as a people in the way we have been coexisting. Should we continue as a people together? I think so, but we need to sit down and discuss how we will continue to coexist. And the conversation is, request for a conversation is legitimate. It is certainly legitimate.
Let's come to the judiciary. One of the positions you took when you appeared at one of the sessions was that the number of appeals should not be limited to the Supreme Court because of quality and lack of confidence in rulings and judgments coming from the lower courts. Can you expatiate on that?
So, I believe in litigants having the right to ventilate their grievances up until the highest level. That's my own philosophical bent. Now, should the jurisdiction of the Supreme Court continue as it is forever? Arguably, no. Is this the right time for us as a country to reduce the jurisdiction, the appellate jurisdiction of the Supreme Court? I don't think so. And I'll try to be scientific about this, or I think that the approach should be scientific. There was a time the Court of Appeal, for instance, was the final appellate court for governorship election disputes. The National Assembly changed that situation and now reverted to what was before, under the 1979 Constitution, to the Supreme Court being the final appellate court. Now, there were reasons why the National Assembly took this step. So, let's go to the answer of the National Assembly as to what informed that decision. So, what mischief was the National Assembly trying to cure? Now, has that mischief been cured to necessitate a reversal to that status quo? If that mischief has been cured, fine. So if you are saying that, well, what made us, if the National Assembly is saying that what made us change the status quo or the pre-existing status quo is also now manifesting, so let us, for that reason, just go back, and the problem has still not been solved. The problem still remains. So for me, I don't think we've gotten to that point yet where the jurisdiction of the Supreme Court should be reduced. When we get to that point where judicial outcomes are trusted and respected by the generality of the populace, then we can reduce the jurisdiction of the Supreme Court. But as at now, when quite a number of people are still disenchanted with judicial outcomes, I believe that people should be allowed the maximum opportunities to ventilate their grievances.
Because I'm thinking, if it is about outcome and the fact that people don't trust judicial outcome, would it matter if it stops at the Court of Appeal or it goes all the way to the Supreme Court? People are still not going to trust the system anyways. And then we have a situation where we say that the courts are very clogged. So taking all the cases all the way to the Supreme Court is not helping the situation.
So, you see, that exactly is my point. Why don't people trust judicial outcomes? Right? Is it because cases go all the way to the Supreme Court? That's not the reason. Right? It's not because cases go all the way to the Supreme Court that people don't trust or, sort of respect judicial outcomes in certain circumstances. So, reducing the jurisdiction of the Supreme Court will not solve that problem.
But the same argument could also be made that if you reverse the status quo, it still doesn't change anything.
Yes, so let's address the reason why judicial outcomes might not be trusted.
How do we address it?
So, one, the appointments procedure, and quite a number of lawyers, the NBA has been canvassing for a review of the appointment procedure so that the important considerations will be merit, character, competence. So, when you have a system that those are the prevailing considerations, you certainly would, judicial outcomes certainly will be trusted. And let's face it, as of today, not all cases go to the Supreme Court anyway. you can again introduce the process of leave to appeal. So put in stringent conditions to allow a full ventilation to the Supreme Court, so that you just don't curtail the right altogether. You can put sort of a stopgap that is stringent conditions for applications for leave to appeal.
Welcome back. The Twitter ban of the federal government continues to generate reactions, with many lawyers describing it as unconstitutional. We have the views of two of such lawyers up next.
Let me state clearly that the president has erred the law by placing a ban on Twitter. You see, the use of Twitter by Nigerians is guaranteed under Section 39 of the Constitution as part of their freedom of expression. It is guaranteed under Article 9 of the African Charter of Human and People's Rights. It is guaranteed under Article 19 of the Universal Declaration of Human Rights, 1948. Particularly, that article says that they can express themselves through any medium and regardless of the frontiers. So, where the president has derived that power to curtail freedom of expression from, I don't know. Now, that particular act has also had terrible implications for freedom of the press, for freedom of religion, for right to earn a living. Freedom of the press, because all Nigerian press houses have Twitter handles with which they propagate freedom of the press. Freedom of the press because many Nigerians do some form of journalism on Twitter now, and they disseminate information. Now, freedom of religion. They were joining issue with Pastor Yu Adeboye, and Pastor Kumuyi, because they insisted that they would continue to use their Twitter handle to propagate their religious belief. Now, the attempt to stop them or the threat to prosecute them is an affront on their freedom of religion. We are no longer in England of 1670 when William Penn was prosecuted under the Conventicle Act for exercising his right to religion. We are no longer in that age. We are not in a police state, and every person who has been given the mandate to exercise power must exercise it in accordance with the law. Now, they have this right, and the law guarantees the right. Now, beyond that, now I have about commercial freedom of expression. When you go to Twitter, many Nigerians do all sorts of things there. They do buying and selling there. They do advertisement there. They do marketing there. Some do several commercial activities there. And you now want to stop them. It then means that you are denying them their right to earn a living. So we will not take that and will not accept that. And I also wonder how the Attorney General came about the idea that he wants to begin to prosecute people for continuing to use Twitter. Has the pronouncement of the president become law that is now a basis to prosecute people? Has the Attorney General, the learned Attorney General, forgotten that Section 36 sub 8 and Section 36 sub 12 of the 1999 Constitution of Nigeria as amended has confined prosecutorial power to only things that constitute an offense as at the time they were done, and only offenses that were defined and written. Has it forgotten? So the learned AG should sit up, and I appreciate the fact that he was appointed by the law, he was appointed to the instrumentality of the law, and he must conform to law when exercising his power.
The whole Constitution has given us rights. The federal government cannot by any means or by any guise take away this right. This right has been provided for in Section 37 and Section 39 of the Constitution. Particularly if you look at Section 37, this right, the right to telephonic and telephone conversation and thereabout, is holistic. There is no proviso to that section, that's Section 37. No exception, no clause. That section is holistic. That section is standing on its own. There is no A, there is no B. Section 37 is Section 37. So the federal government cannot come to the back door and take the right that has been given to Nigerians by Section 37 and Section 39 of the Constitution. Perhaps they may want to hide under Section 49 and Section 45 of the Constitution and under the Cyber Act Provision Act 2015 to find justification or to find reason for this illegal suspension placed on Twitter. But there is no justification. No matter how you try to look at it, no matter how you try to analyze it, no matter how you try to justify it, there is no justification. You cannot take through the back door what the Constitution has given to us through the front door. Are you getting it? Now the issue is this. When similar thing happened in US, did Trump ban or suspend Twitter? He didn't do it. That is because over there's freedom of expression. Their Constitution provides so. And over there, they respect this constitutional provision. There's respect for rule of law. There's respect for Constitution. Over there, power belongs to the people and not to the government. But in Nigeria, reverse is opposite the case. In Nigeria, our rulers, permit me to use that word, they don't respect Constitution. Every day we see constitutional violation in this country. But as the court resumes, we shall go to court to challenge this illegal suspension placed on Twitter.
And just before we go, a recap of some of the top trending legal stories in the news.
Staying with issues of the Twitter ban, a civil society organization, the Socio-Economic Rights and Accountability Project, SERAP, and 176 concerned Nigerians have filed a lawsuit against President Muhammadu Buhari at the ECOWAS Community Court of Justice in Abuja over his government suspension of the microblogging platform Twitter. The suit was filed on Tuesday, June the 8th by SERAP's counsel, Senior Advocate of Nigeria, Femi Falana. In filing the suit, SERAP and the others argued that the suspension of Twitter is aimed at intimidating and stopping Nigerians from using the platform and other social media platforms to assess government policies, expose corruption, and criticize acts of official impunity by the agents of the federal government. They are therefore seeking an order of interim injunction restraining the federal government from implementing the suspension of Twitter in Nigeria and subjecting anyone, including media houses, broadcast stations, using Twitter to harassment, intimidation, arrest, and criminal prosecution, pending the hearing and determination of the substantive suit. Away from issues of the Twitter ban, courts across the country are to reopen on Tuesday, June the 15th, after the public holidays on Monday. The reopening of the courts is equal to the suspension of the 2-month-old nationwide strike embarked upon by the Judiciary Staff Union of Nigeria, JUSUN, to press home their demands for financial autonomy. JUSUN decided to call off the strike following the intervention of the Chief Justice of Nigeria and the National Judicial Council, NJC. The union resolved to suspend the industrial action during its National Executive Council meeting, which held on Wednesday, June the 9th in Abuja. A memo signed by its Deputy President, Emmanuel Abioye, after the meeting pleaded with the NJC, the Presidential Implementation Committee, the Attorney General and the Accountant General of the Federation, along with other stakeholders, to see that the issue of judiciary financial autonomy is laid to rest as approved for in the Constitution. The President of the Nigeria Bar Association, Olumide Akpata, has however disclosed that the monitoring committee set up by the NJC will address these and other concerns. A statement signed by the NBA President on June the 9th says the monitoring committee will be chaired by a retired Justice of the Supreme Court, the Emir of Lafia, His Royal Highness Justice C.D. Bagge. Other members of the committee are the President of the National Industrial Court, Justice Benedict Kanyip, the Chief Judge of Abia State, Justice Onwaha Ogbe, and the NBA President and the Senior Advocate of Nigeria, Dr. Muiz Banire. Meanwhile, the Federal High Court has issued an exemption of payment of default fees for filing of processes practice Direction No. 2 of 2021 for the period of the JUSUN strike. The practice direction, which was signed by the Chief Judge of the Court, Justice John Soho, will come into effect from Tuesday, June the 15th, 2021.
And that's our program this week. Don't forget that you can find these and past episodes of the program on our YouTube page. I am Shola Shayeli. Thank you for watching and see you next week.